Hello, my name is John Giacomo. I'm an internet lawyer with Revision Legal, and I'd like to talk to you today about the differences between a domain name dispute under the Uniform Domain Name Dispute Resolution Policy versus one under the Anticybersquatting Consumer Protection Act, which is a federal statute. So let's start with the UDRP, the Uniform Domain Name Dispute Resolution Policy. Under the UDRP, a complainant has to prove three elements. The first is that the domain name is identical or confusingly similar to a mark in which the complainant has rights. Consequently, the complainant must prove that it has trademark rights, whether common law or registered, and it must show that those rights are coextensive with the term that's located in the domain name. Second, the complainant must prove that the registrant does not have rights or legitimate interests in the domain name in question. And the question here is, has the registrant made a fair use or a bona fide use prior to the creation of this dispute? So sometimes panelists will look at, is the domain descriptive? Is it generic? Was it used prior to the acquisition of trademark rights by the complainant? And those are some of the things that are taken into account. The third element of a UDRP dispute is whether the domain name has been registered and used in bad faith. And this is a conjunctive requirement, meaning that registration and use in bad faith must occur at the same time. For example, bad faith typically cannot arise after registration if the domain name was registered in good faith. So if a domain name is initially registered in good faith and later the registrant or the respondent decides to place pay-per-click ads that are directly competitive with the complainant on the website, it won't be enough. And again, this is a arbitration proceeding, so the precedent isn't really there. And sometimes the prior statement that I just made may not be true. It really comes down to the panelist, but as a general rule, bad faith typically cannot arise after registration. So let's look at the ACPA, the Anti-Cybersquatting Consumer Protection Act. The ACPA requires a plaintiff to prove that the defendant had a bad faith intent to profit from the use of a mark in a domain name, and that the defendant registered, trafficked in, or used a domain name that is either identical or confusingly similar to a mark that is owned by the plaintiff, is dilutive, meaning it dilutes a famous mark, or that the mark is otherwise protected under the ACPA. And this typically is in the case of a Olympic mark or the marks of the Red Cross. Both of those are kind of carve-outs to the ACPA that get almost a special status. So let's talk about bad faith. What is bad faith under the Anti-Cybersquatting Consumer Protection Act? Well, bad faith is it's a question of several factors, and these factors are non-exclusive. First, courts look at the trademark rights of the defendant. Does the defendant have any trademark rights? Second, they look at whether or not the domain name consists of the defendant's name or otherwise identifies the defendant. Is it the defendant's personal name? Is it a descriptive name that relates to the defendant? These are the types of things that courts look at in an ACPA claim. Third, ACPA courts will look at the defendant's prior use of the domain name in connection with a bona fide offering of goods or services. Did the defendant use this domain name for legitimate purposes, or are they simply cybersquatting? Are they simply warehousing domains, or are they just selling goods or services under what they believe to be a descriptive or generic term? Another element is defendant's intent to divert consumers from the mark owner's online location to its own or to some other third-party site. This is typically an element in a typo squatting case, which is a case where a defendant uses a typographical error of the complainant's mark to refer traffic to a third-party website for the purpose of commercial gain. The next element is the defendant's offer to sell the domain name. And typically, offers to sell, if they're greater than out-of-pocket costs, will be seen as a large bad faith item. The next question is, has the defendant provided false or misleading contact information within the WHOIS database? So when you look at the WHOIS record associated with the domain name, Did the defendant provide false or misleading contact information? Are they using a privacy protect service? These are the things that courts look at. The next question is, did the defendant warehouse domains? Does the defendant have a large portfolio of domains containing the trademarks of others? Does he or she have thousands of domain names used to siphon off traffic from popular websites? These are the types of questions asked under this element. And finally, again, these are not exclusive, but the last element that's listed in the ACPA is the strength of the mark of the plaintiff. So is the plaintiff's mark descriptive? Is it generic? Or is it arbitrary or fanciful or suggestive, the kind of more distinctive categories of trademarks within the trademark spectrum? So let's talk about the practical differences between a UDRP claim and a ACPA claim. UDRP claims are filed with typically one of two arbitration bodies, the National Arbitration Forum or the World Intellectual Property Organization. In contrast, ACPA claims are filed in federal court. So ACPA claims are pretty significant. Federal court is a pretty serious place, and therefore the ACPA is a pretty serious body of law. UDRP, Uniform Domain Name Dispute Resolution Policy filing fees are around the $1,500 mark. In contrast, ACPA, anti-cybersquatting litigation can be incredibly costly. Costs can range anywhere from $20,000 for a very brief ACPA lawsuit all the way up to $1 million depending on the number of domain names and the scope of discovery. Additionally, UDRP remedies include only two very limited remedies. You can either have the domain name transferred to you, or you can have the domain name canceled. The ACPA, in contrast, allows a plaintiff that is successful to gain up to $100,000 in statutory damages for cybersquatting. So if you can prove certain cybersquatting elements, you can get up to $100,000 in damages. Additionally, the ACPA allows for cost and attorney's fees. So though the ACPA has a lot of costs that go with it because it's a federal court claim, it also has a lot of benefits. And it's important to, if you're deciding what route you should go, to talk to an attorney about these issues, because a good attorney will tell you what your return on investment is either under the Uniform Domain Name Dispute Resolution Policy or under the Anti-Cybersquatting Consumer Protection Act. Again, my name is John Giacomo. I am a partner with Revision Legal. I'm an internet lawyer, and if you have any claims under the UDRP or the ACPA, feel free to contact me. I'd be happy to talk with you. Thank you.